checking in with you one more time. I would like to discuss Michigan's no-fault statute. That's the statute where theoretically anyone injured in a motor vehicle accident will receive his or her personal injury protection benefits directly from the at-fault, no-fault insurer. That's called PIP benefits, PIP, personal injury protection benefits. That's the way it's supposed to work. We have a pretty good law. It's a little bit complicated. There's been some changes to the law, and that's the reason I wanted to get together today and discuss a few of the changes. In 2019, the changes that went into effect were quite significant. The one that we're going to talk about today has to do with the statute of limitations, or the timeline in which a injured party has to file a formal lawsuit against an at-fault or responsible insurance company. Prior to 2019, a claimant had a hard and fast 1 year from the date of the accident to file his or her formal lawsuit. After the 2019 changes, a claimant still has to file their notice of claim, provide reasonable proof to the insurance company within 1 year, but the insurance company must issue a formal denial of the claim before that 1 year statute of limitations begins to run. That's the 1 year period of time that a claimant has to file a lawsuit. So the takeaway from this is, if you're an injured party involved in a car accident, within 1 year of the car accident, you need to notify your insurance company that you've been involved in a car accident and that you have a personal injury protection claim that you're submitting against the insurance company. And you have to provide reasonable proof to the insurance company. They may contact you and ask you for some medical records or authorizations to obtain medical records, and you need to provide them with those records. Once the insurance company has received reasonable proof of your no-fault claim or your personal injury protection claim, you have 1 year from the time that insurance company denies that claim to file a formal lawsuit, either retain counsel or file a formal lawsuit in the appropriate district court or circuit court seeking your recovery. This also means that insurance companies have to take note. They have to make sure that they receive the reasonable information that they need, and they have to make sure that they file a formal denial of claim. This is not a telephone call, this is not some form letter, but it should be a formal denial of claim. And the insurance company would want to do that promptly, because not until that formal denial of claim is served upon the claimant does the 1 year statute of limitations begin to run. Insurance companies like finality, so it's, if you want your 1 year statute of limitations to expire, the sooner you get the denial in, or the sooner you make that claims decision, the sooner you'll know whether you're going to have a lawsuit on your hands or not. This is a very important change. 2009 from the it happened in 2019 from the earlier laws. There are other changes that have occurred. If you should have any questions regarding Michigan no fault, please feel free to contact me. I'm Attorney Peter Angelus, Law Offices of Alexander and Angelus PC. We're in the Detroit metropolitan area. We'd be glad to assist you.